All right. Today is another day, and we are coming to learn land law. Land law. In our previous discussion, we look at allodial title. Allodial title. We said that we have 6 registrable interests. 6 registrable interests. 6 registrable interests in land, according to Section 81. Section 81 of Land Act 2020 at 1036. And then we have 7 registrable rights, according to Section 82 of the Land Act 2020 at 1036. And then we came back to Section 1 to talk about this registrable rights. And then we discuss allodial title. Allodial title. And under allodial title, you got to know that is the supreme, per what Benchi Enchel said. And then we analyze a lot of cases on Haman versus AJ. So that is how it is. Today we are going to look at another aspect, which is number 2, objective. By the end of the lesson, you should be able to discuss the customary law freehold with relevant authorities, because we have already dealt with 1 allodial title. So 3, discuss the common law freehold with relevant authorities. These are the 2 that we are going to discuss under this topic. Before we dive into it, let us pay respect, 10 to 15 seconds respect, to the Land Act 2020 at 1036, because it has done us much good than harm. So let us pay respect to it. All right. So quickly, let us zoom into what we have. What we have on table today. What we have on table today. This is where we ended from our previous discussion under allodial title. 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 So under this discussion, we are going to start with what is called customary law freehold. In fact, there is a tiny line between customary law freehold and the common law freehold. Common law freehold. In fact, it's very, very tiny. Very, very tiny. They look alike. Don't forget that according to Article 11, I'm just chipping this one in. It is not part of our discussion, but I'm just chipping it in. According to Article 11, which talks about the sources of law in Ghana. In fact, the laws of Ghana shall comprise this constitution, enactment made by or under the authority of the parliament established by this constitution. Any orders, rules, and regulations made by any person or authority under a power conferred by this constitution. The existing law. The common law. What is the common law? Let us read the common law. Article 11, clause 2. The common law of Ghana shall comprise the rules of law generally known as the common law, the rules generally known as the doctrines of equity, and the rules of customary law, including those determined by the Superior Court of Judicature. So it means that, especially in land-related matters, when you are talking about land-related matters, and then you are talking about customary customary. Then the next one is common law. Customary law, common law. The reason being that before the colonization, we were having our customs. But when Ghana was being colonized, Gold Coast was being colonized by the Britain, they established two courts. There was another court of which the local people, or let me say the local authorities, were mostly called to come and sit on the traditional issues, such as the land matters and those stuffs. So we're having the customary law aspect for the land and its related matters. And then we're having the common law aspect. So because of that, we have customary law, freehold, and we have common law, freehold. That is why I'm saying that almost the two of them are the same. Just a tiny line. It is only a tiny line. So if you understand it from here, it will make them become related to you. Just a tiny line. Just a very, very minute. So they are almost the same. So let's begin quickly with the customary law freehold. That is the B. Customary law freehold. When we talk about customary law freehold, we are making reference to section 3, Pick Your Land Act. Make sure to pick your land act. Section 3. Let's finish reading it before we dive into the lesson. Section 3 of the Land Act. Section 3 of the Land Act, titled Customary Law Freehold. Customary law freehold is an interest which arises from a transaction under customary law. So a transaction under customary law is underlined. A transaction under customary law. It is an interest which arises from a transaction under customary law. And it is an absolute interest in land which is not subject to any proprietary obligations. It is not subject to any proprietary obligations, but is subject to the jurisdictional and cultural rights of the stool or skin or clan or family which holds the allodial title. Let me finish with it so that I can explain them one after the other. Which holds the allodial title. Acquired, B. Acquired when a person or a group of persons, where the law permits, purchase land outright from the stool or skin or clan or family which holds the allodial title, or acquired by gift or inheritance. And C. So here the A is B. Acquired. From the acquired is B. And then C. The B is C here because of the bulletin. B here is C here. Acquired when a person. C of perpetual duration and is inheritable and alienable without the consent of or payment to the stool or skin or clan or family. Section 3, subsection 2. Subsection 2. The acquisition of customary law freehold interest by a non-citizen in respect of stool and skin land has since the 22nd day of August 1969 been proscribed. So that is all under section 3 of the Land Act 2020 at 1036, section 3. Now let us take our time to dissect and bisect it. We are taking our time to dissect and then to bisect it. If you look at it carefully, you could see that there are certain points that you have to take note of. Number 1, we are talking about customary law freehold, it is an interest. And this interest, it is an interest. And this interest arises from a transaction. Please. From a transaction. A transaction. It must arise from a transaction. Transaction, it means you are buying. Transaction is buyer and seller. Don't forget. It must arise from a transaction, buyer and seller. We have seen the allodial title is the supreme. It belongs to the land. So the Ashanti Kingdom, the king is there. The Ashanti Kingdom, the king is there. But we too, we buy lands. In your hometown, you buy land. In my hometown, I buy land. So when I am buying land according to customary law freehold, that transaction, I will purchase it, I will give money, and they will give me the land. It is a transaction. Don't forget. It is a interest in land. This interest in land must arise from transaction. Number one, transaction. It must arise from transaction. This transaction could be number one, outright purchase. Outright purchase. Purchasing the land outrightly. So outright purchase of the land from the stool or skin or clan or family, which was the allodial title. So the family or the clan or the stool is the one that is holding the allodial title, supreme. And then I come to the stool, the paramount chief or the king, and I come and buy a land from them. So under customary law, then you become customary law freehold. Or a gift. It could also be a gift of the land from the stool, skin, clan, family, which was the allodial title. That one also is a transaction. You give me the land and the customarily, you go and give what is called aseda. Aseda, thanksgiving, aseda. You go and give snap. They go and give any cola nut. They go and give any customary medium of giving thanksgiving to the person who gave you aseda. And then you go for aseda. Transaction. Or inheritance. Or the land from the stool, skin, clan, or a family which holds the allodial title. It could also be by the means of inheriting from your parents or inheriting from a particular stool. So it is a transaction. Don't forget. Number one, we have gotten to know that it is supposed to be a transaction. A transaction. The interest in land must arise from a transaction. Don't forget. And then these transactions are outright purchase, gifts, inheritance, or the land. Another point that you shouldn't forget. Number one says interest in land. Number one. The element number one, interest in land. Number two, this interest must arise from transaction. Number three, this transaction must be a transaction under the customary law. It must be a transaction under the customary law. What does the custom of that particular society say? If you move according to the custom of that particular society or under the jurisdiction of that particular stool or skin, then we are saying that it is customary law. Number 4, from what we read from the Land Act. Number 4, with respect to proprietary obligation, the holder of the customary law freehold is not subject to any proprietary obligations of the stool. The proprietary obligations of the stool you cannot force the person to be doing this, doing that. No, the person has bought the land. He could use it to do whatsoever he wishes to use it for. The person can use it to do whatsoever he wishes to use it for. However, with respect to jurisdictional and cultural rights, because you can't pick your land from the town, you can't pick your land from the town or from the place and send it to different place, but your land is under someone's land. Your land, your plot is under someone's stool, If the whole town, they are saying that during festive occasion, no one is supposed to play drums, you must observe that. It is jurisdictional and cultural right. And at the same place, if they are saying that Tuesday, we don't go to this area, under jurisdictional and cultural right, you must obey. If in that time we are saying that no one is supposed to marry more than 2 under jurisdictional and cultural right, it is for the whole town, so you have to obey it. So the holder of the customary law freehold is subject to the jurisdictional and cultural right of the stool or skin or clan or family which holds the allodial title. So understand it. They are not subjected to proprietary obligations, but they are subjected to jurisdictional and cultural rights. I hope you are getting it. Aisha, if you're able to do this, you're good to go. Number 1, customary freehold must be an interest in land. Number 1. Number 2, this interest in land must arise from a transaction. This transaction could be outright purchase, gift, or inheritance. Right? That is number 2. Number 3, these transactions must be transaction under the customary law. Under the customary law. Number 3. Number 4, with respect to proprietary obligations, the holder of the customary law freehold is not subject to, so simpliciter, the holder of the customary law freehold is not subject to any proprietary obligations. Number 5, but is subject to jurisdiction and cultural rights. That is the principle under the customary law freehold. That's the principle. The customary law freehold is of perpetual duration. Number 6, it is of perpetual duration. When you buy it, it is your property. You have bought it. When you are even dying, you can do well and give it to your children. The customary law freehold is of perpetual duration and it is inheritable and alienable. When you say inheritable, it means your children can inherit or someone can inherit. Alienable means you can sell it, you can give it out, you can dash it to someone, can gift it out. It is your property. So remember that the customary law freehold, it creates an outright authority over the thing. So it becomes yours, perpetual duration, and is inheritable and alienable without the consent of or payment to the stool or skin or clan or family. Once it becomes yours, it is yours. The acquisition of customary law freehold by non-Ghanaian and of any person in stool and skin lands were prescribed by the 1969 Constitution. So, from according to Section 3, subsection 2, that is where you could see this. So this one is under subsection 2 of Section 3. So we have analyzed Section 3. So in all, this is the end to customary law freehold. Customary law freehold. Up next, we are going to talk about common law freehold. Common law freehold. Common law freehold. So be expecting our next lesson as we dive into common law freehold. Once again, my name is Alexander Osei Kwame Possible. You can call me Sir Possible for short. Until we meet again another time, I will say bye-bye for now.